So, hi, computer guys, we are here for which subject?
Admin.
Administrative law. So, we have done first subject, we have done professional responsibility, first intro. Then we have done first intro, which one?
Civil law.
Which one?
Civil law.
Civil
Civil.
law.
Third, fundamentals.
Jurisdiction.
Fourth, administrative law. So, before I'm gonna teach administrative law, just I need your eye contact. Do not write, I need your proper attention. Client came to my office for the purpose of taking, no, for the purpose of general inquiry. Tiana, for the purpose of taking general inquiry. He is not even my,
Prospective client.
Plan.
he is not even my prospective client. Number two, client first contact with law firm. First contact with law firm, disclose his name, only name. Name is not a confidential name. So he became my
Prospective client.
prospective client. And couple of example, first contact with law firm, there is a couple of examples. Okay, first contact. With first contact, he discloses confidential information
Client
Um,
and relationship.
client.
or
Client.
client
Legal.
relationship exist. Today is a very good news. Today is a barrister exam. Everyone is calling me today. I have done half an hour before. I have done 20 minutes before. I have done 10 minutes before. Everyone is saying barrister for for paralegal, we will rock. Mark my words. Okay, doesn't matter. Now you came to my office. I'm a paralegal. Think like a paralegal. Act like a paralegal. Behave like a paralegal. My first job is whether this is my permissible scope of practice. Permissible scope of practice or within my practice. Yes, this is in my practice. If not my practice, I'm gonna refer to another lawyer or another paralegal. Okay, yes, this is my scope of practice. Second job, Tiana, conflict checking system. Third, identification. Fourth, verification. After the verification, retainer or
Non-written.
non
Non-retainer.
retainer with your signature, non-retainer with your signature. If you will refuse to make a signature and leave my office, I have to make a, I have to ready non-engagement and make a memorandum. These are all important points. Memorandum, this guy, he refused to make a signature. And last known address, send it to his
That
last known address. Retainer or non-retainer. If retainer, he gonna give me a $1,000. $1,000 when to deposit to the trust account, maybe today, must be next banking day. I will teach in next classes. Okay, this is our last chapter. Anyway, two or more people came to my office. Who is my client? Oh, you are my client? He's your family member? I have to take you to the private room. How I'm gonna deal with your friends? Because your confidential information may become, not maybe, must be compromised to your family member. Are you comfortable? Comfortable is gonna go into
Retainer.
retainer. Always every single thing gonna go into retainer. Okay. Now you are my client. Identification, verification. He is instruction agent. Identification, verification. He gonna give me a money. Same way identification and verification.
Verification.
All people are my. Everyone is talking. Who is my client? All people are my client. From Tiana, which rule applicable?
Bylaw.
joint,
No, no, Tiana.
joint retainer. Joint client.
Joint
Joint
client.
client. Right?
Joint client can be two, more than one. More than one can be two, can be three, can be four, can be five. Joint client. Okay, you are my joint client with there are three bullets. I have to inform joint client, no problem. One of them is vulnerable. Tiana, one of them is vulnerable. Okay, you know what? Law society require me. I'm gonna inform you. Bring ILA. Both of them bring ILA, independent legal advice. Independent legal,
Advice.
Advice.
independent legal advice. Bring ILA. If you will bring ILA, no problem. If you will not gonna bring ILA, still no problem. I have done my due diligence. Make sense?
Yeah.
Yes.
Yes.
Okay. Okay. So both came back. One of them said, I'm gonna hire that lawyer. Then I have to withdraw from both of them unless departure client gonna consent me. Then I will continue. Make sense?
Yes.
Yes.
Client came to my office. How can I help you? Okay, you are here behalf of corporation. Corporation is my client, you are not my client. Is that clear? Clear. First, permissible scope of practice. This is, I'm a
Okay.
paralegal, whether this is within my practice, yes. Conflict checking system, yes. Identification of the corporation. In next classes, I'm going to ask the question. Identify the corporation. You will give me answer. Verification of the corporation. You're going to give me answer. Then
Yes.
my next question would be, I'm going to ask, oh, you are an instruction agent? Being a paralegal, what's my legal obligation towards my instruction agent? Your
Your
name,
name
your
designation.
position, and your contact
On.
information. I'm gonna take your test. Every class I'm gonna teach. Okay. Then,
Yes.
okay. You got it? Learning?
Yes.
Okay. Now, public law. Public law, first three chapters is not within your permissible scope of practice. First three chapter 55, 56, and 57 is not within the scope of paralegal. After 57, 58 till end is your permissible scope of practice. It means a lot of question gonna come from chapter 58 till end. But first three chapters, but still we have to I will, which important part, that's it. Because this is outside the area of judicial review. As a paralegal, can you go to the court for judicial review?
No.
No.
No. So this is not your permissible scope of practice. No one gonna ask the question. But still, I have to little bit. I have to inform. Uh, Open chapter 57. Okay, we're gonna first of all, first three chapter 55, 56, 57. According to my opinion, no one gonna ask any question because outside the area of your practice. But still, I have to judicial review of administrative action. Yesterday, Nathan, you got it? Judicial review. Again, I have to teach from the start. Okay. Tiana, I need your eye contact.
Okay.
Tiana, I'm a paralegal. Okay. Make a footnotes. Only footnotes. A provincial administrative body versus
Federal.
a federal administrative body,
Federal.
tribunal, or provincial tribunals or administrative body versus federal.
Federal.
Okay. Number one. Now, if you are as a paralegal, I can go to the provincial board, provincial administrative body as a
Mm-hmm.
paralegal. I can go to the federal tribunals, immigration board. I can appear before the immigration board as a paralegal. If case is rejected from the board, although this is not your in your jurisdiction, but still I have to inform. You never know question gonna come from where. If there
Mm-hmm.
is a material, you never know. But according to my opinion, first three chapter, maximum five question.
Okay.
But I will let you know, five to six question. I think now I can go to the okay provincial board. I am unhappy being a paralegal. Of course, I'm here behalf of my client. Being a paralegal in the provincial board, I have to go to the court for judicial review. Which court? If case was Tiana in provincial administrative body, case is rejected. Now I have to go to the court for judicial review. Which
Mhm.
court?
Provincial court.
Provincial court.
Not basically provincial court, divisional court. I will let you know. Or federal to federal. Make sense? Okay. I need your
Okay.
eye contact. I need your eye contact. Judicial review is my constitutional right. Judicial review is my first. I will give you the basic structure. Tiana, do not
Give me,
write.
give me
Uh,
1 second. Give me 1 second.
are you comfortable the way I'm teaching?
So she required some pen to write down, I think.
Sorry.
She required something to write.
First, we have to clear the basic concept. As a paralegal, you need to understand. It doesn't matter. To clear the exam is not a big deal. To clear the exam is not a big deal. The big deal is you have to understand the basic legal structure of Canadian. Okay, Canada basic legal structure, even in the all over the world. Doesn't matter you are from Jamaica, you are from India, you are from China. First, there is a constitution law. Constitution law. So
Mm-hmm.
federal government is in Canada, federal government is highest law making body in Canada. Federal government, then provincial government, then city, private law. These are bodies making up law policies. So no one gonna make any law which is against the Canadian constitution law. Federal government cannot make any law which is against the constitution. What is Canadian constitution law? Charter of Rights and division of power. Yesterday, like Charter of Rights and division of power. Make sense?
Mm-hmm.
So
Yes.
federal government, provincial government, city, even this is my private body. This is my private MC exam. For example, this is my private home. Okay, Jamaican people are not allowed in my home.
Mm-hmm.
My apartment is rental basement. Only Indians are allowed. This is against the constitution, against the Charter of Rights, against the freedom of religion, freedom of expression. You got it? So anyway, just I have to give you advice. Okay, now, okay, so I can go to the court for judicial review. By there are two ways to go to the court. Okay, two ways. By way of judicial review, by way of right of appeal.
Rate of appeal.
Statutory right of appeals is very important points, not examination point of view. No one gonna ask you because this is not your jurisdiction. You cannot go to the court for in future. They are thinking. In future, they are thinking.
Mm-hmm.
Okay, so I can go to the court. For example, decision of the admin body is final and binding with no right of appeal. If wording is decision of the admin body could be provincial government, provincial body, admin body could be federal government. Landlord tenant board, landlord tenant board, provincial body.
Provincial.
Immigration board is a federal body. Their decision is final and binding with no right of appeal. Then I can go to the court for judicial review because my right is protected under Canadian constitutional law. If decision of the admin body, if decision of the admin body is allowing me, there is a statutory right of appeal. Statutory right of appeal mean if you are unhappy with the decision of the admin body, you can go to the court by way of right of appeal.
Rate of appeal.
Right of appeal. Just extra knowledge, although within not your jurisdiction. So I can go to the court for judicial review. Okay, judicial review. If decision of the admin body is final and binding with no right of appeal, it means clearly if no right of appeal, I cannot go to the court for for right of appeal because no right of appeal is available within the statute, within the admin body. Then no one cannot stop me for judicial review. My right is protected under constitutional law. Okay. What is judicial review? Can you, so there are two kind of judicial review. Procedural fairness, substantive fairness. Admin body did not follow the proper procedure or substantive fairness. That's it. Do not go into detail. Procedure mean, for example, I little bit I'm gonna guide, I'm gonna give you advice about admin. For example, I'm a doctor in hospital. I'm a doctor in hospital. I was sleeping while job. Okay. So someone senior came here. He wake me up. Oh, while job you are sleeping. Yes, I was sleeping. Okay. Then of course supervisor gonna call to hospital board, management. Hospital management or hospital board, before they're gonna fire me, before they're gonna suspend me, they have to follow the proper procedure. What proper procedure? Give me a notice for hearing. Notice for hearing. Hearing should be oral. Hearing has to be open. Right to cross-examine. Right. Hearing has to be right to counsel. Everything you have to follow the proper procedure. If you will not gonna follow the proper procedure, if you will, for example, hearing is going on before the administrative body. Hearing is going on before the admin body. Admin body could be provincial. Admin body could be
Federal.
federal. While hearing, they are using three evidence against me. If they
Yeah.
are using three evidence against me, I have a constitutional right to cross-examine to all witness. Cross-examine to all witness. And now you stop. Okay, right to cross-examine, right to cross-examine. When I start right to cross-examine before the admin body, they told me, no, you are not allowed because she is scared. She don't want to come forward. She is under the age of 18 years, whatever the reason is. Sir, you are using this evidence against me. Then I have a right to cross-examine to witness three, all witness, or exclude that witness. Now they are, or I said I'm gonna bring my own right to counsel. Right to counsel could be lawyer, could be paralegal, could be family member. But you are putting the restriction. No, right to counsel only lawyers, not even a paralegal. Violation of procedure fairness. You did not give me a proper notice. You did not give me a oral hearing. You are a bias. Decision maker was biased. Okay. Any issue regarding procedure, then I'm gonna go to the court for judicial review based on procedural ground. Then I'm gonna tell to the judge, judge, I'm a paralegal, although paralegal cannot go to court for judicial review, but we have to remember as a lawyer, I'm here because admin body did not follow the proper procedure. What proper procedure? They did not. Okay. So judicial review is procedural grounds and substantive grounds. Substantive mean, write it on substantive grounds. Judicial review is equal to procedural grounds and substantive grounds. What are the substantive ground? You're gonna write jurisdictional issue, jurisdictional issue between the courts and the admin body. Jurisdictional issue, substantive, jurisdictional issue mean, according to my opinion, for example, aboriginals. Who gonna deal aboriginal? Always courts gonna deal aboriginal.
Mm.
Some matters courts gonna deal. By chance, I went to the tribunals. They think, oh, you are aboriginal, you are half bred, you are not half bred. Decision was against me. Then I realized, oh my God, this is not under your jurisdiction, admin body. This is not your jurisdiction. Then I'm gonna go to the court for judicial review. I'm gonna tell to the judge, judge, I'm here for judicial review based on the substantive ground. Procedure, no issue. Substantive, there was an issue. Substantive mean I'm a aboriginal. You have to dealt, not judge will dealt, not
So
look at my
federal.
body. Okay, it means you are not present mentally. Okay, no problem. Who am I, Tiana?
Paralegal.
Paralegal.
Paralegal. Right now, I'm i- in front of,
The
before
judge
Court.
the, before the judge. For here, for what purpose I'm here?
for substantive
Judicial review.
No,
for
no, for Tiana, judicial review based
yeah,
on
substantive ground.
Attention.
substantive ground. Substantive ground mean, judge, I'm here because according to my opinion, matter has to be dealt before the court, not before the,
Tribunal.
right, Tiana?
Not before the what? Sorry, I couldn't hear that last part.
Before the tribunal.
The tribunal.
Do you know what is tribunal actually? Do you have any idea? Tribunal, administrative bodies,
Yeah,
landlord-tenant board, immigration board, human rights
tribunal.
board, tribunals. So this is tribunals, right? As a paralegal, you can go to tribunals, right?
Yes.
Yes. Okay, I'm not gonna focus too much. Okay, number chapter 57. Chapter 57, Judicial Review of Administrative. First three chapters, I'm gonna give you idea, very strong idea. You will remember maximum 4 5 question, maximum. Otherwise, next chapters are very important. What is judicial review? 58 7. Point number two. First page. Can you read?
Pursuant to Section 96 of the Constitution Act 1867, the courts have supervisory jurisdiction over administrative decision
Well,
making.
who are supervisor of the admin body?
Constitution,
Constitution.
the
Constitution is
courts,
how he constitution gonna supervise you. Is not
uh,
human
the
being.
court, the court has
Courts.
supervisory. The
Judge
courts have.
gonna supervisor on the road. Who is a supervisor on the road? Police. Okay. So if you are unhappy with the decision of the admin body, look at my body language. If you are unhappy with the admin body, so who is the supervisory role? Courts.
The courts.
Okay, keep reading next paragraph.
Judicial review is the way that courts oversee
No, no, next
administrative
paragraph.
decision. Oh, next
Okay.
paragraph. Although paralegals may not act on a judicial review application, it is important to be aware of the principles of judicial
See,
review.
it is important to aware of the principle of judicial review. It means it can be still important. Although you in your not in your jurisdiction, but still it is important. Whenever book is telling it is important, it means it is important examination point of view. Okay. To principle of judicial review. Okay. Please reading.
Yeah. A paralegal, oh no, you said you want the
Yeah,
next.
paralegal acting.
Okay. A paralegal acting before a tribunal should ensure that the record before the tribunal is significantly is significantly complete to support a judicial review.
Highlight. See, book is referring to paralegal. Book is referring to paralegal. Then always, no, always. Book is referring paralegal. Then always
Like,
important.
mhm,
Nitin bhai, always important. Okay, just
Always
one question. Just one time I'm gonna tell. If I'm asking day versus you are
night,
quiet, it means you are out of town. That's why I always stop and evaluate whether you are learning or you are not learning. Yeah, this is my way of teaching. Just I'm gonna advise day versus
night.
night. If you are quiet, it means you are out of time, out of town. Boy versus girl, right? So that's why I always saying provincial court, provincial tribunals versus
Federal.
federal tribunals.
federal term.
If you are quiet, you are out of town, out of town. Okay. So paralegal acting before a tribunal should ensure that record before the tribunal is sufficiently complete to support a judicial review is the exact answer. That's it. That's your jurisdiction. That's it. Okay. Then 2.1.
2.1. How is judicial review different from an appeal?
See,
Although
okay,
in some ways,
stop. I can go to as a paralegal, not as a paralegal, because paralegal is not my jurisdiction, but it is important. Be aware of principle. Okay, so we can go to the court for judicial review if by way of judicial review, if a statutory right of appeal is available, then by way of statutory right of appeal. See, how is judicial review different from an appeal? Appeal means statutory right of appeal. Okay, read.
although in some ways a judicial review resembles an appeal, it is distinct from an appeal in several respects. First, a right of appeal is a statutory right and must flow from some legislative instrument. Conversely, a judicial review is generally available for final decisions of administrative
That's it.
tribunals.
This is sufficient. This is sufficient. Number three is very important. Can you read from me, please?
There are two main venues in which a judicial review can be pursued. Federally, before the federal courts, compromising the federal court and federal court of appeal.
Stop. So federal, if we are unhappy with the decision of the federal tribunals or federal administrative body, example, immigration board, federal, then we are unhappy, we can go to the court for judicial review based on procedural grounds and based on
No grounds,
substantive grounds.
substantive grounds.
Based procedural and substantive grounds. Which court we gonna go if I'm unhappy with federal administrative tribunals? Which court?
Federal
Federal.
court.
Federal Court of Appeal. If landlord tenant board, I have to go to the court for judicial review against landlord tenant board. Then which court? Divisional court.
Division.
Write it down. No, not write it down. Written in the book. Keep reading, please.
Okay. And provincially before the divisional court. In addition, in limited circumstances, the Superior Court of Justice can oversee some administrative action.
That's it. You got it?
Yes.
Okay. Number 5, only 2 lines.
In both the federal courts and the divisional court, a request for judicial review is brought by way of notice of application.
That's it, by way of notice of application. In both federal courts and divisional court, a request for judicial review is brought by way of notice of application. What is the first step to brought judicial review before the provincial, divisional court or federal court? First step is notice of application. That's it. Although this is not under your jurisdiction, but we have to clear the exam as well. That's it. You don't need to even read nothing. It's total wastage of time. Knowledge, if you want to get the knowledge, I'll give you knowledge. You can call me 24/7. Doesn't matter. You are my student. You are not my student. You're going to retain my services. You will retain my service. If you need extra knowledge, 10 100 times a day, you can give me a call. Constantly give me a call. Oh, I need to, I'm eager to learn. Eager to learn. I'm ready to give you all. I don't care 1 hour, 2 hour, 3 hour. Right now, if you're gonna give me a time or there is no time limit, let's see, 3 hour, 4 hour, 5 hour, 6 hour, 7 hour. I don't care. You got it? But first priority is to clear the exam. That's it. Number 6.
Time for filing an application for judicial review. As soon as a paralegal becomes aware that judicial review is a possible option for the client, the paralegal must turn his or her mind to the time limits for filing an application for
Again,
judicial
see, paralegal must turn. It means book is referring, paralegal must turn. Most important. If book is referring, paralegal must do it. It means most important to clear the exam. Or timeline. Timeline mean doesn't matter provincial government, provincial tribunals, doesn't matter federal tribunals, case is rejected, then we have a 30 days. We have a 30 days after the impugned decision. We have a 30 days after the decision, we can go to the court for judicial review by way of notice of.
application.
Notice
Oh,
of application.
yes. Beautiful. Notice of application. That's it. Next paragraph.
Just read. Application. Okay. Next paragraph. For number 6, right?
Yeah.
In the federal courts, an application for judicial review must be made to the appropriate court within 30 days after the impugned decision is communicated to the Deputy Attorney General or to the
That's
party
it.
directly
That's
affected.
it. That's it. That's it. Because as a paralegal, this is sufficient information. This is not under your jurisdiction, but basic knowledge you have to learn. That's it. Again, I need your eye contact. I'm a paralegal. I'm a paralegal. Being a paralegal, I can You are my client. I can go to the provincial tribunal. I can go to the federal tribunals. Okay, being a paralegal. If case is rejected from immigration board, deputation order, or whatever landlord tenant board, we have lose the case as a paralegal. First job. What is the first job? We have to take care whether see paralegal acting before a tribunal should ensure that record before the tribunal is sufficiently complete to support a judicial review. Number two, chapter 7, number 2, second paragraph, fourth line. Record before the tribunal is sufficiently complete to support a judicial review. Your record, each and everything, Mr. Chaudhary, I'm a paralegal, we have lose the case. This is not under my jurisdiction to go to the court. Record is complete to support judicial review. Now, Mr. Chaudhary, you have 30 days. Being a paralegal, you must inform me. Being a paralegal, hey, you have 30 days. You can go to the provincial court or you can go to the federal court within 30 days after the impugned decision of the admin body by way of notice of application. You got it? That's it. That's it. You got it?
Yes.
Any question so far?
No.
No. Okay. Okay. Now we can go to the court for judicial review based on the procedural grounds and based on the
Federal grounds.
not federal ground, procedural grounds and
Substantive.
Substantive.
substantive grounds. Substantive mean, according to my opinion, matter has to be dealt before the courts, not before the
Tribunal.
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 Tribunal. Okay. Now substantive. In the substantive, court first job to determine which is a standard. There are two standard. Standard could be reasonable. Standard could be correctness. Judge will determine which standard applicable. Standard. Just cut copy paste because not your under jurisdiction. Okay, standard. There are two standard. One standard. Judge will determine which standard. Standard could be reasonable. Standard could be
Correctness.
correctness. Write it down. Reasonable mean admin body have a jurisdiction. Reasonable, write it down. Reasonable mean administrative body have jurisdictions, not court. Standard gonna be procedure. Or standard is what I told?
Judicial
Re-
review.
reasonable. Reasonable mean
Okay.
administrative jurisdiction. If judge will determine standard gonna be correctness, because correctness, then court have a jurisdiction. That's it. Reasonable and correctness. Okay, read standard of review. Okay,
Yes, standard
okay,
review.
yeah, yeah.
The standard of judicial review refers to the level of difference the courts show to an administrative decision maker. There are currently two standards of review: reasonableness and correctness.
So
On
reasonable mean who have a jurisdiction
administrative bodies have jurisdiction.
and correctness,
Correctness,
court have a jurisdiction.
court has
Court.
jurisdiction.
No, okay. On judicial review.
Jurisdiction. Okay. On judicial review, a court will first determine the standard of review to be applied to the administrative decision in question. At
It's
this,
always, always, okay, always very important. First determine. As a paralegal, my first job is as a administrative body, their first job will be as a court, their first job will be always very important. A court will first determine, very important. If facts are, I went to the court for judicial review based on substantive grounds, what will be the first job as a judge? The court as a court.
Determine.
Court will determine which
Determine.
standard. Standard could be reasonable. Standard could be
Correct.
correctness. Read it again.
So at this stage, the reviewing court determines whether the administrative decision is held to a standard of correctness or whether it need only be reasonable. Next, the reviewing court will determine whether the
This is done.
administrative
This is done. This is done because this is not your jurisdiction. This is done.
okay.
7.1. Understanding the two standard of review. There are two standard. Which one? Which one? There are
The
two standard.
standard correctness and
No,
reasonable.
not B and A. Start always how to B, A, C, D, E. Is a wrong. A, B, C. Reasonable and correctness. Not correctness and reasonable.
Sorry,
Reasonable and correctness.
correct.
Okay. So 7.2, 7.2, second paragraph.
There is now a presumption that the reasonableness is the applicate standard on judicial review. This means that the most administrative decisions will be reviewed on a standard of reasonableness.
That's it. You got it? Presume to be reasonable standard. Judge will presume reasonable standard unless I will prove no standard would be
Correct.
correctness. Beautiful. Correctness. That's it. This is done. This is it. Number eight, don't worry about number eight, relief available. I will explain. But which important point is relief available? Okay. So this is last paragraph is very important. See, importantly, last paragraph number eight, relief available last paragraph. Importantly, important. Okay. Refer to paralegal, always important. What is the first job for the paralegal? Always important. What is the first job court will determine? Always important. There was a growing problem is always important. Or it is important to know is always important. See, importantly, please read it.
Importantly, while their decisions may have financial consequences, neither the federal courts nor the divisional court may award damages on a judicial review.
There are, however, able to award cost between the parties. That's it. Not damages, only cost. Very important point. Although not in your jurisdiction, but still we have to understand. Okay, example. Mr. Nathan and Tiana, they were in the provincial tribunal. They were fighting, they are fighting. Ultimately, case brought up to maybe federal court or maybe provincial divisional court. Okay, maybe Tiana win the case. Tiana gonna say, I need damages because of because he break the contract. He break the contract. He broke the contract. After broken the contract, I have lose $200,000. Court can award damages. Court can award damages. $200,000. Yes or no, Tiana?
Yes.
Yes. Okay. Read importantly again.
Importantly, while their decisions may have financial consequences, neither the federal courts nor the divisional courts may award damages on judicial
Neither
review.
mean not.
No, they can't.
It means they cannot award damages. Damages mean, Tiana, my name is Tiana, sir. I have lose $200,000 because of Nathan did not honor the contract. So court gonna say, I will not gonna give you cost only between the parties. For example, cost between the parties. For example, I give my $3,000. I give my name is Tiana, sir. You are not allowed to give me a damages. Damages is my $200,000 because I he break the contract. $300,000. But cost mean I pay paralegal before admin body $5,000. Okay, then I hire lawyer. I give him $10,000, $15,000, then court fees $20,000. Then judge gonna say we are able to award cost between the parties. It makes sense?
Mhm.
Not
Yes.
damages, only cost, which I spent from my pocket.
Mhm. Got it.
Make sense?
Okay.
Thank you. So there is, okay, that's it. This is done. This is it. Okay, before we gonna go for a little bit break, I need your eye contact. Okay, just relax. I'm a paralegal. I'm a paralegal. I can go to the provincial tribunals. Example, landlord tenant board. I can go to, okay, landlord tenant board. I can go to federal tribunals. Example, immigration board. Okay, both are. Now, being, okay, if we're gonna lose the case, if we're gonna lose the case, being a paralegal, my job is first job after losing the case before admin body. Paralegal acting before a tribunal should ensure that the record before the tribunal is sufficiently complete to support the judicial review. Your file is complete, sir. Miss Tiana, I'm a paralegal. Sorry, we lose the case. File is complete, record is your. Number two, Tiana, you have 30 days after the impugned decision you received. Very important. Now you can go to the court for judicial review within 30 days by way of notice of application or by way of which court? Provincial court, then of course divisional court, provincial divisional court. If federal, then superior court of justice, superior court. Make sense? Then we can go to the court for judicial review based on procedural ground, based on substantive ground. Procedure, they did not follow the proper procedure. Administrative procedure, substantive ground. Substantive ground mean, according to my opinion, matter has to be dealt before the courts, not before the
Tribunal.
tribunals. Very excellent. Very excellent. Okay. Then there are presumed to be reasonable standard. According to presumed to be reasonable standard, okay, what is the
Right.
first judge will determine whether are standard is reasonable
Reasonable.
or
Or
standard is
Correct.
correctness.
correctness. Presumed to be reasonable. Reasonable mean admin body have a jurisdiction. Unless there is rebuttal, then court will have jurisdiction. That's it.
Okay.
See, did you learn?
Yeah.
Yeah.
Love whatever you do. Honestly, I'm telling you, love whatever you do. Don't think lawyers are superior than us. Absolutely not. Absolutely not. They have a, with due to respect, they think, oh, we are lawyer, we are lawyer, we are lawyer. But knowledge wise, don't ask me. Paralegal is more professional degree than the NCA. I'm not against NCA. I'm a tutor of NCA. I'm a tutor of barrister. I'm a tutor of solicitor, or I'm a tutor of American, uh, New York and California bar. I do teaching. I have a books right here. Yeah. See, these are all books. These are all books. American. See, these are all American books. These are all American books. See. So anyway, you got it?
Yes.
Okay. So now, do we need some break?
Yeah. 10 minutes.
A little
10
bit.
minutes. Okay.
And then,
See you right after 12 minutes. 12
Okay.
minutes, 9:15 Ontario time.
Thank
9:15
you.
Ontario time, 12 minutes. Thank you.
oh,
Bye. Yes. Okay. So chapter 55, 4.1 is important. For sure is important. 4.1 statutory reconsideration or appeal mechanism. First bullet, second bullet, third bullet are extremely important. Okay. For example, second bullet, Residential Tenancy Act in your jurisdiction. Residential 4.1, Chapter 55, 4.1, second bullet, Residential Tenancy Act 2006. Can you read?
Residential Tenancy Act 2006. An order of the Landlord and Tenant Court can be appealed appeal to the divisional court, but
Answer
only
is divisional court, but only on a question of law within 30 days.
30.
Always within 30 days. That's it. Residential Tenancy Act. As a paralegal, you can go to the landlord tenant board. As a paralegal, you can go if you lose the case, then which court we gonna go?
The divisional court.
Divisional court within 30 days by way of notice of application. Then last bullet.
Human Rights Code. A party may request that the Human Rights Tribunal of Ontario reconsider a decision in accordance with the tribunal rules. The tribunal's rules restrict requests for reconsideration to final decisions. The code provides that tribunal decisions cannot be appealed.
Cannot be appealed. Okay, if you are human rights code mean, for example, my employer. For example, I'm a paralegal. My employer client came to my office. So he said, I have a complaint against my employer because of he was violating my human rights code. Human rights code, he is giving preference over white people, over brown people, over black people, over religion, sex, greed, everything. Okay. Then, okay, then he went to which court? Human rights tribunal. He lose the case in human rights tribunal. So tribunal case is final and binding with no right of appeal. Then can he go to the court against human rights commission? No.
No.
Okay. Okay, no. I need to eye contact. As we mean, of course, lawyers, basic knowledge. We can go to the court for judicial review. No one cannot stop me for judicial review. If decision of the admin body is final and binding with no right of appeal, then we're gonna use another way. Another
Okay.
way is judicial review, because decision cannot be appealed, statutory appeal. You understand? We can go to the court for judicial review because our constitutional right. If two options are available, silent, 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 silent by way of appeal. Appeal, or there is no option for a right of appeal, then by way of judicial review. That's it.
Okay.
Got it? So we can go to the court for judicial review if
Judicial.
both options are available. Oh, decision of the admin body is final, but there is a statutory right of appeal. Mean now we can go to the court by way of statutory right of appeal.
Okay.
If this option is not available, no one cannot stop this option because my constitutional right. This is my not legal right. This is my constitutional right. Constitution is broader than the legal. You got it? This is my constitutional right. Freedom of religion, my constitutional right. So federal government cannot even make any law which is against my constitution. What is constitution? Constitution is my judicial review is my constitutional right. No one cannot stop. You got it? Okay.
Yes.
Number one, Ontario Disability Sport Program Act. While you are employee, you got accident or anywhere you got accident injury. Who gonna make a decision whether you are injured for permanent injury, maybe for limited time of period? Who gonna make a decision? Director, original decision. So first step is director decision. Okay, for example, I'm gonna say I'm in the hospital, I have a back pain. So there was a Ontario Disability Sport Program. They're gonna hire one director. So who will make a determination whether I'm a permanent disabled or for 1 year disabled, for 5 month disabled. So disability. First step is a director original decision. Then, if I'm unhappy with the director original decision, then I have to go to the internal review of the director decision. Second step is fourth line. Internal review of the director decision is a second step. Ladder approach. Third is social benefit tribunal. Mean this is your jurisdiction. 100% is your jurisdiction, then 100% is important. For example, I'm driving a car, someone hit me from the back, or I'm an employee. There was an injury. According to my opinion, injuries for limited time of period for 1 year, for 2 year, 5 year. Who gonna make a decision?
The director of original decision.
Director decision under Ontario Disability Support Program, Ontario. Director is saying, Mr. Chaudhary, you are go to go. You are ready. There is no pain. I'm unhappy. Then I'm gonna use it. Then I'm gonna go to internal review of the director decision. Third
within
step,
30
if again, if I'm gonna lose the case, then third step is social benefit tribunal. As a lawyer, you can go. Read first bullet.
Ontario Disability Support Program Act 1997. An appeal of some of the director's original decisions may be made to the Social Benefits Tribunal, but only after first seeking an internal review of the director's decision. An internal review must be sought within 30 days of the decision.
That's it, that's it, that's it. You got it? This is done. See, but rest of 4.3 judicial review, you already knew. Judicial review, you already knew. Then number five, procedural entitlement. Number five, okay, right to be see. Don't worry about it because this is not your jurisdiction.
Oh,
Whole is not. I can teach if you want, but there is wastage of your time because time is approaching. You have to write an exam in July, 27th of July. Even if you don't need to read. Number six, substantive review. See, number six, substantive. See, number six, substantive, chapter 55, number six, substantive, read after the bullets. See, substantive review, sub procedural grounds, substantive review. I can go to the court for judicial review against the admin body. Judicial review is based on procedural grounds, based on substantive grounds. Substantive. In the substantive ground, now, sir, you are a judge. I am unhappy with the decision of the admin body, not based on procedural ground, based on substantive ground. So, first, court will determine which standard, reasonable or correctness. Reasonable mean admin body have a jurisdiction, correctness, court have a jurisdictions. Presumed to be reasonable. Okay, read. Okay, after the bullets.
the first step on judicial review of the
See,
substance of
first step, always important. First step is always important.
impugned decision made by a statutory decision maker is to determine the appropriate standard of review for the issue under review. Since the Supreme Court of Canada's 2008 decision in Dunsmuir v. New Brunswick, there have only been two standards of review, correctness and reasonableness. VAL establishes a presumption of reasonableness for all matters under review. The presumption can be rebutted in favor of a correctness standard in two
So
situations.
don't worry about it. That's it. This is done. This is it. Because this is not your jurisdiction. Then
Oh,
chapter 56, little important for some points are very important. Number chapter 56, practice before administrative tribunals. It means in your jurisdiction. Practice before administrative tribunals in your jurisdiction. Who you are?
paralegal.
Parallel.
parallel.
Senior. So, point number two, material to examine before the hearing start. What material to examine before the hearing start? I'm a paralegal. Think like a paralegal. Act like a paralegal. Behave like a paralegal. Client came to my office. Okay, you are unhappy with your employer. Now you wanna go to the immigration board, or you wanna I'm gonna take your case to federal board or provincial board. Okay, no problem. Being a paralegal, my first job, which material to examine before the hearing start? Number one, legislation or statute. Write it down. Legislation oblique statute. Read the legislation statute. Number one. 2.1, legislation and statute. 2.2, read regulations and bylaws. Regulations and bylaws. Read number three, rules of the tribunals. Very important. Being a paralegal. Being a paralegal, material to examine before the hearing start. Which material? There are couple of options. Couple of options gonna be wrong. Couple of which, for example, all of them are present. Then answer all of them. First, read legislation, statute. Number two, regulations or by law. Number three, rules of the tribunal. Okay. Can you read? Number two, start from the second paragraph.
The paralegal should read the statute that creates the tribunal and the statute that empowers it to act or decide in the instant case.
That's it. That's it. See, tribunal and the statute. ठीक है? You got it? Paralegal should read. It means refer to paralegal. Always important. Right, Tiana?
Yes.
Okay. Paralegal should read. Always important. Okay. Then last paragraph 2.1. Very important.
Further, the legislation may indirectly affect a
No,
party's
last
proceedings.
paragraph, 2.1, last paragraph, two line.
Oh,
One should have available for ready consultation the SPA Evidence Act and good. No, this could be important. Last two lines could be important. I will explain later. Then read
okay.
number 2.2, regulation.
In a number of situations, the tribunal's powers may be prescribed, expanded, or restricted by the applicable regulations. Some tribunals have powers set out in their bylaws. The paralegal should obtain a copy of the applicable regulations or bylaws and ensure that they are up to date.
Very important. That's it. This is sufficient. Being a paralegal, client came to my office. Client came to my office. These are fact pattern. Client came to my office. So he is interested to take his case to tribunal. Which tribunal? Maybe provincial court, provincial tribunal, maybe federal tribunals. Administrative tribunal or admin bodies are same thing. So what is the first job? As of course, first job, material to examine before the hearing start. Which material have to examine? Legislation, statute of the admin body, legislation or statute, regulations, bylaw, and rules of the tribunals. Must read. That's it. Okay. It is either it is appeal subject to. Okay, 2.5 is very important for paralegals. Can you read 2.5 prior decision?
If the proceeding is either a review of a prior decision or an appeal subject to the restrictions on paralegal scope of practice, it is obvious that the paralegal must carefully review the decision or order being reviewed or appealed.
Very
It,
important. Paralegal must carefully, very important. Because book is referring, paralegal must carefully. Always very important. Make sense?
yes.
Thank you. So paralegal must clearly, if there are couple of options according to situation, that's it. This is done. Then what are the important? Now is important is 3.2, 3.2, even 3.3 witness rights, one paragraph above 3.3. One paragraph above 3.3 witness right, one paragraph above is gonna start note that.
Note that Section 12 allows a tribunal to issue a summons to compel a witness to attend at a hearing and produce documents. A
Okay,
paralegal.
hold on. Okay, just 1 second. For example, Triana,
Mhm.
you have some incident. You have some incident. You are saying Nathan is my witness. You're gonna talk with Nathan, please come forward for witness. And he is not coming forward to witness. He is not coming forward to the witness. Now you're gonna go to tribunals and you're gonna ask tribunals, please, admin body, force Nathan to come forward for witness by way of summon to witness, by way of warrant to witness. What? What
That
mean
means
what? WHAT, I'm asking what? By way of summon or by way of witness, by way of warrant?
Summon. First
Summon.
summon.
Summon to
Summon.
witness.
Yeah.
Always cut a copy paste in your jurisdiction. For example, Tiana is saying, Nathan is my witness. Nathan, please come forward for the witness. Nathan saying, no, I'm not gonna be part of any proceeding. I don't want. Then you're gonna request before the admin body, please force Nathan to come forward. So admin body gonna issue
Summon.
summon to
Summon.
witness. Summon to witness one time, Nathan will not gonna appear. If second time summon to witness, third time, fourth time, finally, admin body gonna
Until
issue warrant. Warrant. Police gonna come, arrest you, take you to the in front of. Make sense? Very important. Got
Okay.
it?
Yes.
So
Yes.
after the, you know what? Last 2 weeks, minimum last 2 weeks before the exam, I'm not gonna teach. I'm gonna ask the question. Constantly, I'm gonna ask the question. Then you have to give me answer. Open book test, refer to the book. Open book test, refer to the book. Make sense?
Yes.
Okay. 3.4. Evidence. Evidence. One topic is the evidence. Yeah. Can you read?
In general, the rules of evidence before an administrative tribunal are less strict than the rules applied in a court proceeding.
That's it. Rules of evidence. One, rules of evidence before the tribunals, rules of evidence before the
court.
Court.
court. Exactly. Court are very strict in rules of evidence. Administrative bodies are less strict. Rules of
Okay.
evidence. For example, before the okay. For example, example is gonna read. For example, second last paragraph. Gonna read. For example, second last paragraph.
Pagan.
For example,
For example, a tribunal to which the SPPA applies may receive hearsay evidence. It
hearsay
may
evidence. Okay, but court will not gonna accept hearsay evidence. Hearsay evidence mean what is hearsay evidence? Okay, okay. Tiana is saying I heard from some third party hearsay evidence,
yeah.
but court will not gonna accept because rules of evidence are in courts are very strict. Rules of evidence before the tribunal is less strict. This document is a code. This document is under oath. They will accept under oath. Under oath. Okay, document is not okay. Okay, this document court not under oath. Court will not gonna accept, but admin body gonna accept. Keep reading, please.
Under oath. It may also accept into evidence a document even if the document is not proven under oath. Remember that the admissibility of evidence does not determine the extent to which the tribunal will treat that evidence as reliable or the weight that the tribunal will give to that
Next.
evidence. In addition, under Section 16, tribunals can take broader judicial notice of facts, particularly specialized facts within their expertise than courts usually do.
Okay, its last paragraph is very important. When determining the applicable approach to evidence, very facts are when determining the applicable approach to evidence. Always paralegal should review Evidence Act first, SPPA is Ontario statute second because you are becoming Ontario paralegal, not other than Ontario. Okay, third, tribunal's rules of procedure. That's it. It's very important.
Okay.
So next time, okay, this is done. For example, I'm gonna ask last 2 weeks, every day I'm gonna take your test. I'm gonna make a question. I have a lot of question. I have a lot of question. Tiana gonna read the question. There gonna be a four option with explanation. So you have to give me answer. Answer is B. Why B? Tell me. Refer to the book. Then there are gonna be an explanation. Why? Why do you think? Exam. You got it? So
Yeah.
first I have to give you basic knowledge. Structure. Structure is You got it?
Complete.
Yes.
Yes.
Structure is, for example, structure, PR, fundamentals, civil litigation, administrative law, criminal law. So we have to play within the structure mean stop here, stop. Client came to my office. My first job as a paralegal within my permissible scope of practice, within my area of practice, within my jurisdiction, yes. Then conflict checking system, identification, verification, no problem. Then he's saying we have to go to the admin body. So before for hearing, oh, next week you have a hearing. So being a paralegal was my first job. Review before the hearing. What material we have to review before the hearing? You gonna give me answer. Okay, what? Tell me.
The legislation of the
Very
statute,
good.
regulations, and then the rules.
Yes. Hearsay evidence is a topic. Hearsay evidence. Rules of evidence are less strict in courts or less strict in admin. Where? Answer is.
They're more strict in courts. They're less
Ah,
strict in tribunal. In
exactly. So how many standard?
two
Two.
Which one?
standards.
Reasonable and correctness.
Reasonable and correctness.
Correct.
Presumed to be
Presumed to be
reasonable.
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 Okay, correctness. I can go to the court by way of judicial review. There are two kind of judicial review. Which one?
Judicial review, procedural and
Substantive.
substantive.
Very not substantial, substantive.
Substantive.
Substantive grounds, procedural and substantive ground. Yesterday I taught summary offenses, indictable offenses, hybrid offenses, what is in your jurisdiction, what is outside the jurisdiction. So again, tomorrow, according to the schedule, day after tomorrow is class, day after tomorrow. But day after tomorrow, I'll be busy. So is it possible tomorrow I'm gonna take your criminal law class tomorrow,
Okay,
Yeah.
8:15 to 9:45.
that's fine.
Yeah. That's good.
That's fine.
That's
Okay.
fine.
So number five is also important. Chapter 56, number five, alternate dispute resolution.
ADR.
Yeah.
It is recognized that the
You can read. Okay. I have to call. Okay. Facts are witness is not coming forward. What is the easy way to bring witness before the admin body?
To
um
summon that witness.
Summon to witness. Summon to witness.
witness, witness.
Constantly, he is not appearing before the admin body.
Then the warrant.
Warrant to witness. Warrant. They're gonna arrest you. You make sense?
Yes.
Yes.
So, so are you learning?
Yes.
Yes, sir.
That's it.
Am I good to read?
No, that's it. First
Okay.
three chapters, after the third chapter, 57, open 58. Landlord and tenant, 100% in your jurisdiction. Landlord and tenant board,
Yes.
58, you can go in 58. Very important, landlord tenant board, very important. 59, what is the name of 59? Workplace safety and insurance laws, 100% under your
Jurisdiction.
jurisdiction. 60 chapter is human rights. Okay, one test.
Disability.
One test. As a paralegal, you are violating human rights tribunals, human rights code. As a paralegal, you are violating human rights code. Mean based you are discriminated based on color, religion, sex. Where to complain?
Uh,
Great.
judicial review.
You are
First of all,
100% out of
tribunal.
town. You are 100% out
Tribunal.
of town. Where to
First of all,
complain? Okay. Before you have to understand my question.
Mhm.
I'm not saying where to go for judicial review. Complain to judicial review. Doesn't make any sense.
Human
Judicial
rights
review.
level.
Complaint. Complaint. If you
Human
are
right
going to
tribunal.
the court,
Human
if
right
you are going to the court for judicial review, this is not complaint at all.
Oh, you're going there.
tribunal.
Yes. Judicial review is your right. It's not complaint. Okay. So the my question was,
Who do you complain to?
if you are violating human rights code,
They're violating human rights code.
To the human right tribunal.
chapter number, I think PR,
Please fine.
chap, chapter number, I think or one or point number last, or chapter number three, point number last, I think. I don't know. Open chapter number one or chapter number three, last topic. Dis
Oh, the resolution department.
Discrimination and Harassment Council.
Okay.
Past harassment council.
Violating human rights code,
Oh,
being a paralegal. Oh, you know what? You are my employee. You are a black employee. You are a white employee. You are a Muslim. You are Indian. You are a non-Indian. You are a disabled. I'm making a discrimination towards my employee, towards my client. So violating human rights commission, always refer to someone gonna call to not law society. Discrimination and Harassment Council program established under the law society. Law society is not a free. Law
Hmm.
society allocate lot of things, redelegate to different departments. Oh, call to here, call to here, call to here, call to here, call Law Pro, call Human Rights Commission, call there, call there. Then investigation should be in writing. So I'm gonna ask the question.
okay.
You got it? Did you really learn?
Yes.
And
Yes.
yesterday class was very boring because of 50% good, 50% bad. 50% good, Nathan was present. Or because of you, class is 100% good. The way you are reading, yeah, I'm telling you, Tiana, that's my promise to you. Both of them, I'll promise you. Promise you. If exam is 160, you will get 150 marks. Mark my word. Mark my words.
Thank you, sir.
Okay.
Thank
Wish you all the best of luck. See you tomorrow,
you.
8:15 for criminal law. It's very
Okay.
important.
Done.
So before
Yeah.
tomorrow, you're gonna watch my class.
Yes.
Tiana, you
The link's
must
up,
watch.
right? The link's up, right, for the class from yesterday?
Yeah.
Yes.
Okay, I'm gonna watch it right now.
Thank you.
Okay.
Thank you so much.
Okay.
Welcome. Bye.
Have a
Are
good
you
Well,
100% happy with my teaching, Tiana and Tiana?
Yes.
yes,
Yes,
sir.
I'm really excited.
Any
Definitely.
deficiency?
Yeah. I
Mhm.
remember everything from day one. I'm really like I'm good. I'm good. Day one with PR, good.
Okay. Thank you.
Thank you so much.